charged with aggravated robbery, and in each cause number ending in 2530, and both counts you're charged with aggravated sexual assault. The range of punishment in each of those cause numbers is anywhere from 5 to 99 years or life in prison. Did you? 2023 CR 2703, 2023 CR 2704, and 2023 CR 2530. State of Texas versus Tyrone Eads. Is it Eads or Eads? Eads. Can I have parties announced for the record for the state?
Gabriel Escobar for the state of Texas.
Defense?
For the defense.
And are you Mr. Eads?
Yes, ma'am.
Counsel, have you received all the discovery in each cause number, and did you review that discovery with your client?
We have, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Mr. Eads, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
State, and cause number ending in 2703, are you proceeding on the indictment as presented?
Yes, Judge.
And in cause number ending in 2704, are you proceeding on the indictment as presented?
Yes, Judge.
And in the cause number ending in 2530, are you proceeding on the indictment as presented?
Judge, just one moment. There was no notes on the file itself.
All right, just 1 minute. I'll be able to tell you.
Thank you, Judge. Sorry about that.
That's okay. Yep, there are 2 counts.
Oh, does it say on there, Judge? Yeah, does it say on there, Judge?
No.
Oh, I was proceeding on that.
Oh, okay. Proceeding as presented, Judge.
All right. And each cause number ending in 2703 and 2704, you're charged with aggravated robbery. And in each cause number ending in 2530, and both counts you're charged with aggravated sexual assault. The range of punishment in each of those cause numbers is anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in each of these cause number?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Eads, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the pleas? Anyone promised you anything other than the pleas?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the causes are to run concurrently. State is going to be taking in consideration 2023 CR 2702, 2023 CR 2705, and cause numbers ending in 2703 and 2704. If the court determines there's an affirmative finding of deadly weapon, then the court will enter an affirmative finding of deadly weapon. And that is the same in cause number 2530. And according to the plea bargain agreement, the punishment is to be assessed at 30 years in the prison. Did you understand that to be the plea in each of the cause number?
Yes, ma'am.
Defense? State?
Yes, Judge.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Then in cause number ending in 2703, how do you plead? Guilty, not guilty, or no contest?
Contest.
And the cause number ending in 2704, how do you plead? Guilty, not guilty, or no contest? And in cause number ending in 2530, how do you plead? Not guilty, guilty, or no contest?
Contest.
State any evidence.
Honor state would offer states civil one each of the separate causes. We had a chance to review, Your Honor, no objections.
In each of the cause numbers, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, in each cause number, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, but most importantly, there will be no live witnesses? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments in each cause number, and the court will review the same. All right. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we would ask the court go along with the plea bargain as it has been tendered by the state. My client is taking full responsibility of the matter. My understanding is he even has written a letter of apology in the sexual assault case. And so we would ask you to give him credit for all the time served and give him the plea bargain amount.
All right. And the cause number ending in 2703, the court will find you guilty. The court will find there's an affirmative finding of a deadly weapon. There's to be no contact with Daniel, Laura, and John Albert Elizondo. This will run concurrent with 2023 CR 2704, 2023 CR 2530. Take in consideration 2023 CR 2702 and 2023 CR 2705. Is there anything else with regards to sentencing in that case? And the cause number ending in 2704, court is finding you guilty. Court is finding an affirmative finding of deadly weapon. There's to be no contact with Daniel, Laura, and John Albert Elizondo. Court will sentence you to 30 years in the prison. And I'm sorry, and the cause number ending in 2703, in case I didn't say it, the court has sentenced you to 30 years in the prison and give you credit for any time served. And back in cause number 2, ending in 2704, Court is going to sentence you to 30 years in the prison, give you credit for any time served. And this is to be concurrent with 2023 CR 2703 2530, taking consideration 2023 CR 2705 and 2702. Is there anything with regards to sentencing under that cause number?
No, Your Honor.
And then in cause number ending in 2530, your plea of no contest was to both counts 1 and 2, is that correct?
Yes, Your Honor.
Then the court will find you guilty in count 1 and count 2. Count 1 and count 2 is to run concurrently. Court will sentence you to 30 years in the prison, give you credit for any time served. There's to be no contact with the complainant. This is to run concurrent with 2023 CR 2704, 2023 CR 2703. There's an affirmative finding of a deadly weapon, taking consideration 2023 CR 2705, 2023 CR 2702. There's to be Chapter 62 compliance. Is there anything else with regards to sentencing in that cause number?
No, Your Honor.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapon or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
21.
All right, so 30 years, that's a lot of time. But do not go to the prison and become institutionalized. Eventually, you'll be released from prison. And if you don't change your ways, it's not going to go well for you in this world. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
5 CR 003228, State versus Edgar Pettis. Can I have parties announce?
Agent Pettis for the defendant.
And are you Mr. Pettis?
Yeah, yes, ma'am. Good morning. How you doing?
Good morning. How are you doing today?
I'm all right so far.
All right.
Yeah. Looking forward for today, man. I just woke up.
Okay.
Yeah.
Are you ready to proceed?
Yes, ma'am. Yes, ma'am.
All right. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am. I understood everything.
Are you the same Edgar Pettis who was placed on deferred adjudication in 2025 CR 003228 for the offense of theft of property 2,500 to 30,000 on April 25th, 2025 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
On or about the 22nd day of May 2025 in Bear County, Texas, the defendant Edgar Pettis committed the offense of criminal trespass violation of condition.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, deny the motion, then petition ISD, follow tap recommendation.
Is that what you're asking the court to do?
Yes, Your Honor.
All right, sir, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am. I swear.
All right, you can lower your hand, state your name for the record.
Edgar Pettis.
All right, why are you not doing well on probation? What's going on?
No, I just been having some family problem, I don't like to make excuses, but, I've been having some family problem, but,
Well, what's the problem? Because they're saying you're doing, you're committing a new offense.
Yeah, it's just cause I've been in the street, man, homeless, and, I know, it's my responsibility to do probation, but, I want, I'm ready to get it done, man, I've been in jail for a long time.
Why are you homeless? What's
Uh,
going on? I know you're homeless because you don't have a home, but
Yeah.
do you not have any family?
Oh yeah, I have family. Like I said, I have some problem with them, but I don't know, man. It's just I don't want to make excuses. I fucked up and I messed up, and I want to get this probation over with. I don't know if you could give me another chance.
All right, so here are your choices. Um,
If I may, Judge,
well, just 1 second. Have you ever been diagnosed with any type of mental health issue or no?
No, man.
All right, yes, you wanted to say something, counsel?
Judge, the long and short of it is he was homeless at the time. He tells me that he has a place to go to now. And I haven't seen for sure, but I believe some of his family is here, which I believe, is that correct? Some of your family's here?
Yeah.
So
my
I-
mom.
Okay, so I believe if he's continued, maybe he'll stay at his mom's house. And
Well,
maybe-
does his mom want him at her home?
I hope so. I don't know.
I don't know,
I
but-
think she's still mad, but I hope so.
Is his mom here?
They might have escorted her to the hall, they might have.
All right. Can somebody check to see if his mom is in the hall? Thank you.
State wouldn't like that language.
All right.
Of course, we have no problems with that if he's continued.
Okay.
Yeah, man, can I talk real quick?
Sure.
Yeah, I just want another chance, last time I was here, I ended up doing 3 months, I did 3 months in county, I'm ready to get to probation over with,
Mhm.
I don't wanna spend my life in jail.
Well, the best way not to spend your life in jail is to abide by the rules and conditions.
Yeah, do things right,
Mhm.
I just want to.
All right, so your mom is not here.
Yeah, my mom's not here.
So I'm gonna give you some choices today because how old are you?
21.
All right, you know yourself better than I know you. Better than your attorney knows you, better than probation knows you. All right, you're on deferred adjudication. That's not a conviction. So if anybody asks you if you've ever been convicted of, this crime, you can honestly say no, because it's not a conviction, it's deferred. If you receive a conviction, then this is conviction of theft. Whether it's a conviction or not, it's still a crime of moral turpitude, which takes you into collateral issues such as it's going to be hard for you to obtain any type of licensing for anything that requires a license. Now, what I can do is I can continue you, or I will sentence you to 18 months in the state jail facility, give you credit for whatever time that you previously served. So you say you've been in custody for 3 months before, that would go towards your 18-month sentence. Or what I can do is I can continue. I'll deny the motion, alter and amend conditions to include a TAP evaluation in custody. And that TAP evaluation is see if you have any drug or alcohol issues. And I think we're gonna have to do a MIC evaluation in custody as well. So which do you prefer?
I would like, the type evaluation. Like I said, I don't like jail, like everybody else,
I don't think anybody likes jail.
Yeah, nobody likes jail, I wanna be outside, doing my thing, getting money, all that,
Getting money how?
working,
Okay.
working, big.
All right.
Yeah, yeah.
So I want to do a TAP evaluation and MIC evaluation. That's to be completed in custody. And have you been using any type of drugs in the past?
No, man.
So why did you become homeless, or how far did you go in school?
Well, I ended up dropping out my junior year, but I just have, I'm gonna be honest with you, I just smoke a little marijuana, but I don't have a drug problem, man.
All right, do a referral to felony drug court in custody. There's going to be 200 hours of community service restitution. You're going to either obtain your GED or get some type of trade school certificate. And once that's completed, the community service hours will be deemed satisfied. Do you have any children?
No, ma'am.
There's going to be proof of employment within 45 days of release, no employment as a home health care provider or with minors, regular reporting by Zoom or in person, field visits 1 time per month until further notice. Probation, is there anything else he needs? Is there anything else you need from the court in order to be successful?
No, ma'am.
All right, good luck to you.
At just 21 years old, Tyrone Eads walked into Judge Boyd's courtroom facing the terrifying reality of spending the rest of his life behind bars. He was up against a massive wall of charges, including 2 counts of aggravated robbery and 2 counts of aggravated sexual assault. Each individual count carried a maximum penalty of up to 99 years or life in prison. Faced with overwhelming evidence, Eads ultimately chose to take accountability. He accepted a negotiated plea deal, pleading guilty to the charges, with his defense attorney noting that the young man had even written a formal letter of apology to his victim. After a careful review, Judge Boyd officially found him guilty on all counts, issuing an affirmative finding that a deadly weapon was used during the crimes. The final sentence handed down? 30 years in state prison, with all counts running concurrently. But before the 21-year-old was led away, Judge Boyd left him with a powerful warning. She urged him not to let himself become institutionalized, reminding him that he will eventually be released, and if he doesn't change his ways now, the world will not go well for him. A massive sentence for a very young defendant. What are your thoughts on how Judge Boyd handled this case? Let us know in the comments below, and don't forget to like and subscribe for more courtroom updates.